Have you been asked to be the executor of someone's will? Hi, Nancy Beauvair here with Agape and NEXsteps. It always has been in the past that people have been very flattered when they've been chosen for such roles as a power of attorney for a loved one or an executor of somebody's will. We've just taken on those roles when we've been asked because we have been flattered that we've been trusted enough by those people to be named to handle their affairs. But what people don't understand is that being a power of attorney or being an executor are fiduciary roles. Now, the actual definition of fiduciary, of course, is a position of trust, which, to reiterate what I just said, we're flattered because these people have trusted us. But there is also a legal component when you take on those roles. You can leave yourself exposed to legal challenges about how you've administered the individual's assets as a power of attorney. You can be challenged on your role as an executor. And when people take on these roles and these responsibilities, almost never has there been any consideration given to the fact that there are legal repercussions potentially for taking on these roles. So estate administration is the topic that I specifically wanted to address in today's topic, and I wanted to talk about some of the issues that do come up with that. Now, as a certified executor advisor, I am well versed in a lot of the issues that do come up and a lot of the obstacles and how to overcome a lot of the problems that can come up, making sure that paperwork is streamlined, making sure that you are operating with as much foresight as you can on what might come up. But today I wanted to address specifically the top 3 problems that come up when administering an estate. Now, the first one might seem quite obvious, and that is, where are the deceased assets? Have you got everything that the deceased had as assets listed and accounted for? This can be difficult if the deceased didn't have a list or didn't share with their family, or more specifically with you as the executor, what all of their assets are. What happens if you go through the whole process of the probate and the estate administration and 2 or 3 years down the road, because yes, that is in all reality about how long it's going to take from the time that your loved one dies until the time that you can finally close the estate. Here in Canada, it is typically minimum of 18 months and can take 2, 3 years or even longer depending on how complex the estate is. So let's assume that you have gone through and you have received grant of probate, you've listed everything, you've paid all the taxes, you've tracked down the creditors, you've distributed all of the assets of the estate to the beneficiaries, and lo and behold, you find that there was a safety deposit box somewhere that was just discovered, or you get notification that there was some hidden bank account somewhere. It's really, really important. I can't stress how important it is that you have a list and are aware of every asset that the testator, the person making the will, has shared with you as the executor, to make sure that you aren't blindsided by any of these types of things. Now, I mentioned about debts and taxes. Well, taxes technically are debts until they're paid. One of the other things that's often overlooked is the issue of making sure that creditors are paid. A lot of people mistakenly think that when the person dies, their debts die with them, but that is not the case. And there is an obligation. The estate becomes the legal entity. That estate owes any of those outstanding debts. So if there is money in the estate and there was, I don't know, let's just say that there was a car loan with an outstanding balance of $38,000. And let's say that you sold that car for $30,000. There's still a debt owing of $8,000, and that has to be paid from the proceeds of the estate. If there aren't adequate assets within an estate to pay any outstanding debts, then it can get pretty tricky. And there is a requirement to try to put those things to rest before you can close out the estate. That's another really tricky thing that you have to watch out for. And I guess number 3 on my list today would be about family feuds. People get attached to certain things, or they think that they didn't get their fair share in an inheritance, or if things aren't clearly defined in a will, that they're to be distributed in a certain way, you can end up with a lot of hurt feelings, a lot of strained relationships, and a lot of issues within the family when it comes to sharing the assets. Now, the main issue, it can be fairly straightforward with things like assets, money, those kinds of financial assets. Things can get a bit more tricky when it comes to personal possessions. So the way to avoid that is to make sure that you have either gifted those items prior to passing, or make sure that you have clearly documented somewhere who gets what and how you want those items distributed. That will save a lot of stress, that'll save a lot of fighting from your heirs, your beneficiaries, your loved ones that you've left. You don't want them fighting over your silverware instead of remembering your legacy with love and kindness. So I'm going to leave that with you now. There are certainly more than 3 issues that come up with estate administration, but I wanted to just hit 3 of them today on this brief video. Hop on over to my website, check out my blog post for this week. It'll go into a bit more detail about these 3 topics. And of course, as always, if you have any questions or if you would like a little bit of help with your estate administration, I'm here to help. Drop me a line on NEXsteps and I'll be sure to get in touch with you, and let's make sure that we've got everything lined up and things happen smoothly for you. Thanks for joining me. See you next time. Bye for now.